The Whittaker family has lived most of their lives in isolation. For decades, they were known only to neighbors in a small West Virginia community. Then the internet found them. Cameras arrived. Donations followed. Content multiplied. And now, in 2026, the story has taken a sharp legal turn. A late-night arrest has shifted this from online controversy to a criminal case. This isn't about YouTube drama anymore. This is the state of West Virginia versus a named defendant. And the charges are serious. According to publicly available court records, John Patrick Rower was arrested on January 16, 2026. The case is filed in Raleigh County under a felony case number. The listed charges include 5 counts of fraudulent schemes, 5 counts of financial exploitation of an elderly or incapacitated person involving amounts above $1,000, 1 count of fraudulent use of a device. Bond was set at $150,000. The alleged activity dates back to on or about June 1st, 2025. That date matters because June 2025 is also when content featuring the Whittaker family began appearing more frequently under certain creators connected to this case. Now, this is a criminal prosecution. That distinction is critical. The Whittaker family is not suing in civil court. The prosecution is being handled by the state. That means law enforcement believes there is sufficient probable cause to pursue criminal charges involving alleged financial misconduct connected to vulnerable individuals. And the legal theory behind those charges is specific. Financial exploitation of an elderly or incapacitated person generally involves knowingly obtaining control over assets belonging to someone who is legally considered vulnerable, whether due to age, disability, or incapacity. Fraudulent schemes charges typically involve intent to deceive for financial gain. Fraudulent use of a device often relates to misuse of payment instruments or access devices. Again, these are charges. They are allegations. No conviction has occurred. Court records show that the defendant has entered a not guilty plea and has been arraigned. The case will proceed through the criminal process. Now, where does this leave the Whittakers? Because this case is not happening in isolation. There are multiple names connected to the broader controversy. One name repeatedly mentioned in media coverage is Eric Carroll. According to statements attributed to him in reporting, he has not been arrested in connection with this alleged scheme. In interviews, he has denied pocketing donations and stated that he received only standard monetization revenue, such as AdSense and platform income. He has said that the Whittaker family was entitled to their share of certain revenues and that he ensured appropriate distribution. Meanwhile, statements attributed to members of the Whittaker family tell a different story. Larry Whittaker has been quoted expressing anger, stating that a lot of money was involved and that he did not know exactly how much was owed. He indicated that both Patrick and Eric collected money intended for building a home, but that the plan never materialized. That unbuilt home is an important thread, because fundraising for a house has appeared multiple times in the Whittaker story, not only involving the currently charged defendant, but also in past campaigns connected to other creators. One of the most well-known earlier fundraisers was organized by Mark Laita, creator of Soft White Underbelly. He has publicly stated that he raised funds for the Whittakers, distributed money directly for expenses, and eventually stopped fundraising due to controversy and backlash. He has not been charged with any wrongdoing, and there are no public records indicating criminal allegations against him. But the house plan, that symbolic promise of stability, has surfaced repeatedly, and each time it has collapsed. So now, as law enforcement alleges that more than $10,000 in donations may have been improperly kept, the broader question expands. How were financial arrangements structured? Were there formal agreements? Were there agency relationships? Were revenue splits documented? Were funds commingled with personal accounts? These are not emotional questions. They are legal ones. Another detail matters. According to reporting, troopers opened an investigation in September 2025, just a few months after the alleged scheme began in June. That timeline suggests this was not a long-dormant issue. Complaints appear to have reached law enforcement within months of content creation and fundraising activity. And the arrest came roughly 4 months after that investigation reportedly began. Now, the public has access to limited docket information online, but not the full felony complaint documents. Without those documents, we cannot see the detailed allegations, only the statutory charges and basic case entries. The docket reflects: felony complaint filed, warrant issued, defendant served, bond set, initial appearance conducted. The defendant was booked into Southern Regional Jail. These are procedural facts. They are not verdicts, but they are no longer rumors. This is where speculation must stop and documentation begins. The question many viewers are asking is simple. If one person has been charged, will others be? Right now, there is no public confirmation of additional arrests. But investigations do not always conclude with a single defendant, and they do not always conclude quickly. It is also possible that this case is narrowly focused, tied to specific transactions, specific accounts, specific digital transfers. Until charging documents are released, the scope remains unclear. But one thing is clear: the use of vulnerable individuals and monetized content is now under prosecutorial scrutiny. And that changes everything. Because for years, the Whittaker family existed in a gray space between documentary storytelling, internet fascination, charity fundraising, and influencer monetization. Now, that gray space has entered a courtroom. And courtrooms operate under evidence rules, not comment sections. This is no longer about who said, won a live stream. It is about bank records, platform payouts, device usage, account access, intent, and statutory definitions. There is also another uncomfortable layer. The Whittakers have often been presented as passive participants, filmed, assisted, spoken for, sometimes interpreted. But in this moment, they are legally classified as alleged victims. That classification matters. It means the state recognizes them as potentially exploited parties under the law. Whether a jury ultimately agrees remains to be seen. But the designation itself reframes the narrative, not as internet spectacle, as criminal vulnerability. So now the story stands at a crossroads. One man charged, another publicly denying wrongdoing, a family claiming money was collected, but a house was never built, and a state prosecutor preparing to present evidence. The internet thrives on immediate judgment. The courtroom does not. The next phase will not be decided by who speaks loudest online. It will be decided by documentation, bank statements, contracts, communication records, platform analytics, and the ability to prove beyond a reasonable doubt that fraud occurred. Until then, the presumption of innocence applies, but so does the seriousness of the charges. The Whittaker family has faced poverty, isolation, viral exposure, internal conflict, and public controversy. Now they face something else, a criminal case that could redefine how their story is told. This is not the end of the saga. It is the beginning of a different chapter, and it will not unfold on YouTube. It will unfold in a courtroom. Comment one word that describes what you believe matters most right now. Evidence, accountability, transparency, or patience. When a case shifts from online accusation to formal prosecution, the most important change isn't emotional, it's structural. The structure changes, the rules change, and the burden changes. Up until the arrest, the Whittaker controversy lived in a digital ecosystem. Videos were uploaded, Live streams dissected them. Viewers donated. Creators responded. Allegations circulated. Screenshots were shared. Narratives hardened. But a criminal case forces a different standard. In a courtroom, statements are not enough. Documentation is required. Let's slow this down. The charges filed against John Patrick Rower include multiple counts of financial exploitation of an elderly or incapacitated person. That specific wording is not accidental. West Virginia law, like many states, provides enhanced protections for individuals considered vulnerable due to age or disability. To prove financial exploitation under criminal law, prosecutors generally must establish that the alleged victim qualifies as elderly, protected, or incapacitated under statute, that the defendant obtained, controlled, or used the victim's funds or assets, that the defendant did so knowingly and unlawfully, and that there was intent to deprive or misuse. That is not a casual threshold. Intent matters. Knowledge matters. Control matters. Then there are the 5 counts of fraudulent schemes. Fraud cases typically require proof of deception, misrepresentation, concealment, or false promises used to obtain money or property. It is not enough that money moved. The state must show why that movement was unlawful. Finally, there is 1 count of fraudulent use of a device. That could involve alleged misuse of payment instruments, debit cards, online accounts, or financial access tools. But without the charging documents, the specifics remain sealed from public view. So what evidence would typically underpin a case like this? Bank transfer logs, platform payout records, GoFundMe disbursement histories, email correspondence, text messages, account login metadata, contracts, if any exist. This is where the story becomes technical, because the Whittaker situation was not a single-channel operation. There were Facebook pages, YouTube channels, monetized videos, donation platforms, possibly Cameo-style accounts. Revenue can flow through AdSense, direct donations, Super Chats, Cash App, Venmo, GoFundMe, third-party fundraising links. Each of those platforms generates its own transaction records, and each transaction creates a digital footprint. If prosecutors believe funds were diverted improperly, they will attempt to map those flows. But here's the nuance many online discussions skip. Revenue sharing agreements in content creation are often informal. Sometimes they are verbal. Sometimes they are assumed. Sometimes they are misunderstood. If there was an agency-style arrangement, meaning one party managed filming, uploading, editing, and monetization while promising a split, then proving fraud requires showing that the split was misrepresented or intentionally withheld. Mismanagement is not automatically criminal. Poor bookkeeping is not automatically fraud. Disorganized fundraising is not automatically exploitation. Criminal liability requires a knowing violation, and that is what the state must prove. Now consider the Whittaker family's public statements. Larry Whittaker reportedly said there was a lot of money involved, but that he did not know how much. That statement cuts both ways. On one hand, it suggests confusion. On the other, it suggests lack of clarity about financial accounting. That confusion becomes central. If alleged victims cannot quantify what they were owed, prosecutors must reconstruct the numbers independently. That reconstruction process can take months. Subpoenas may be issued to Google, YouTube monetization records, Meta, Facebook revenue data, GoFundMe, fundraiser disbursements, banks, wire transfers, and account histories. And if funds were transferred between multiple personal accounts before reaching the Whittakers, tracing becomes more complex. Then there is Eric Carroll's public denial. He has reportedly stated that he received only standard monetization and denied pocketing donations. That statement is significant because it introduces a competing narrative. If two parties are accusing each other of financial wrongdoing, investigators must separate. Who controlled which accounts? Who initiated transfers? Who had password access? Who had signing authority? In digital media operations, sometimes one person uploads content while another manages payment accounts. If funds were routed through one individual before being distributed, that individual becomes the focal point of scrutiny. But absence of arrest does not equal absence of investigation, and presence of arrest does not equal sole responsibility. Right now, only one individual has been charged. That is the legal fact. But cases can evolve. Sometimes additional defendants are charged later. Sometimes investigations conclude with a single defendant. Sometimes plea negotiations reveal new information. And sometimes, after months of review, prosecutors narrow the scope of allegations. Another dimension complicates this case: history. The Whittakers have been involved in multiple fundraising efforts over the years, not just this most recent wave. Mark Laita's earlier fundraising campaigns raised significant sums for food, utilities, and housing assistance. He later publicly explained that the money was distributed over time for ongoing expenses and that taxes were paid by him. He ceased fundraising for the family amid controversy. He has not been charged, but the repeated appearance of house fund narratives across different creators raises an uncomfortable pattern. The house never materializes. Funds dissipate through emergency needs. Expectations rise. Disappointment follows. This recurring pattern creates suspicion, even when no criminal conduct is proven. And suspicion is powerful online. But criminal court requires more than suspicion. It requires statutory proof. Another overlooked factor is consent. If the Whittakers knowingly agreed to a revenue split arrangement, even if the split was uneven, that does not automatically constitute exploitation. Exploitation implies taking advantage of incapacity. So prosecutors may need to show: did the Whittakers understand the revenue model? Did they consent to the percentage distribution? Were representations made about building a house that were knowingly false? Were funds intentionally diverted for personal use? These questions will not be answered through YouTube reactions. They will be answered through sworn testimony. And sworn testimony changes the stakes. Perjury carries consequences. Digital speculation does not. Now consider bond. The $150,000 bond indicates the court considers the charges serious enough to warrant substantial financial assurance of appearance. Bond is not punishment. It is a mechanism to ensure court attendance. If posted, whether in full or via bond company, the defendant could be released pending trial. If not, pretrial detention continues. Pretrial detention does not imply guilt, but it increases pressure. In many fraud cases, pretrial periods involve extensive evidence exchange known as discovery. Defense attorneys request financial records. Prosecutors disclose transaction histories. Expert witnesses may analyze revenue models, and plea negotiations may occur. Fraud cases often resolve through plea agreements, but not always. If this case proceeds to trial, jurors will be asked to determine whether the state proved each element beyond a reasonable doubt, not whether the internet feels angry, not whether commentary channels believe wrongdoing occurred. Beyond a reasonable doubt. That standard is intentionally high. Now here's the broader question. Why does this case matter beyond one defendant? Because it signals something larger. The monetization of vulnerable individuals has largely operated in an ethical gray zone. Documentary channels, charity fundraisers, reaction creators all intersect with revenue. When does storytelling become exploitation? When does fundraising become misrepresentation? When does assistance become control? The Whittaker case may become a reference point for future prosecutions involving digital exploitation. If the state succeeds, it could embolden further scrutiny of influencer-based fundraising tied to vulnerable individuals. If the state fails, it may reinforce the difficulty of criminally prosecuting ambiguous digital arrangements. Either outcome shapes precedent, and precedent shapes behavior. Right now, the only confirmed legal reality is this. One man stands charged. He has pleaded not guilty. The state alleges financial exploitation and fraud. The Whittaker family has publicly expressed anger and confusion over missing funds. Another content creator has denied wrongdoing and not been arrested. And the case is active. Everything else is noise. The next development will likely be procedural. A pretrial hearing, a discovery motion, a bond update, possibly a plea offer. Until then, the loudest reactions will come from the internet. But the decisive actions will happen quietly in a courthouse. The Whittaker story began as a viral documentary subject. It evolved into a charity saga. It devolved into creator conflict. Now it sits inside a criminal docket. And criminal dockets do not care about thumbnails. They care about evidence. Comment below with one question you think investigators must answer before this case can be resolved. Keep it focused. Keep it factual. When a case like this reaches the courtroom, something else begins to surface, something less visible than bank transfers and bond amounts. Control. Not just control of money. Control of narrative. Control of access. Control of who speaks for the Whittaker family and who profits while doing it. Because financial exploitation cases involving vulnerable adults are rarely just about a single transaction. They're about proximity, about influence, about who had the authority, formal or informal, to act on someone else's behalf. And that's where this case becomes more complex than a headline. The charges against John Patrick Rower focus on financial exploitation and fraudulent schemes. But investigators are almost certainly examining a wider ecosystem, one built around content creation, access, and monetization. Let's examine the structure. In June 2025, videos featuring the Whittakers reportedly began appearing under new management. Grocery store trips, household chores, everyday activities presented to an online audience. Monetization followed. Ad revenue accumulates automatically through YouTube's AdSense system. That revenue goes to the account holder, the person whose Google account is linked to the channel. If donations were also solicited, those funds would route through whichever payment method was listed publicly. That matters, because whoever controls the account controls the payout. Now ask the structural question. Whose name was on the monetized accounts? Whose bank account received deposits? Who had login access? Was there a written agreement specifying revenue splits? If not, was there at least a documented understanding, emails, texts, messages outlining what percentage would go to the Whittakers? If funds were meant to build a new home, was that promise documented? Or was it implied? Fraud cases often hinge on representation. If viewers were told, donate so we can build the Whittakers a house, and that house was never realistically planned, prosecutors may argue deception. But if money was instead used for recurring expenses, utilities, food, transportation, and the audience misunderstood the allocation, that becomes harder to criminalize. Intent becomes the fulcrum. And proving intent requires more than showing money moved. It requires showing that someone knowingly misrepresented what would happen with it. Another layer complicates this further: capacity. Financial exploitation statutes involving elderly or incapacitated persons require the state to show vulnerability. The Whittaker family has long been described as intellectually limited, socially isolated, and reliant on others for assistance navigating modern systems. That vulnerability is not abstract. It affects legal thresholds. If someone with diminished capacity is persuaded to grant access to monetized platforms without fully understanding the revenue structure, prosecutors may argue that consent was not truly informed. But defense attorneys will counter with evidence of participation. Were the Whittakers on camera discussing revenue? Did they acknowledge awareness of monetization? Did they sign any platform agreements? Did they receive transfers regularly? If regular transfers occurred, even if amounts were disputed, that complicates a clean narrative of theft. And then there's Eric Carroll. Publicly, he has denied pocketing donations. He has stated that he only received standard monetization and that the Whittakers were entitled to their share. If his involvement was limited to platform management and content posting, investigators will need to determine: did he receive funds directly? Did he transfer funds onward? Was he acting independently or jointly with the charged defendant? Digital investigations often rely on metadata, IP logins, administrative permissions, payment routing histories, two-factor authentication logs. If two people had joint administrative access to a channel, both could technically access payout information. If only one had bank routing control, responsibility narrows. At this stage, only one arrest has occurred. But investigations rarely freeze at the first charge. The timeline matters. According to reports, law enforcement began investigating in September 2025. That means the alleged conduct between June and September triggered concern relatively quickly. That suggests either a complaint was filed or irregularities were identified early. Who filed the complaint? Was a family member? A viewer? Another creator? Law enforcement hasn't disclosed that publicly. But in financial exploitation cases, third-party complaints are common, especially when vulnerable individuals are involved. Now zoom out. The Whittaker family has been the subject of online attention for years. Mark Laita's earlier fundraising efforts raised substantial sums. He later explained that funds were used for recurring needs and that taxes were paid by him. He stepped away. That departure created a vacuum. Vacuum attracts new actors. New actors often bring new promises. New house, new beginning, better management. Each promise increases stakes. Each promise increases donation flow. And each promise creates liability if it fails. But criminal liability is not assigned based on broken optimism. It is assigned based on statutory violation. Which brings us back to the legal structure. 5 counts of fraudulent schemes. 5 counts of financial exploitation. 1 count of fraudulent use of a device. 11 charges total. For each count, prosecutors must establish specific transactions or acts. This is not one generalized accusation. It is count-based. That means investigators likely identified at least 5 separate financial actions they believe qualify as fraudulent. Perhaps multiple withdrawals. Perhaps multiple donation periods. Perhaps multiple instances of alleged misrepresentation. Each count corresponds to a discrete event. Defense attorneys will scrutinize each one. Were funds commingled with personal income? Was there accounting separation? Were any funds demonstrably used for Whittaker expenses? If even partial funds were used legitimately, that may affect sentencing, but not necessarily the existence of fraud. Fraud can occur even if some benefits were provided. The key is whether deception occurred. Now consider sentencing exposure. Financial exploitation of an elderly or incapacitated person can carry substantial prison time, especially if the amount exceeds statutory thresholds. The mention of above $1,000 in the charge classification suggests that prosecutors believe the sums cross felony lines. If convicted on multiple counts, sentencing can stack. That possibility changes leverage during plea negotiations. Many fraud defendants plead to reduced counts in exchange for restitution agreements. Restitution is central here. If the state proves financial exploitation, the court can order repayment. But repayment requires traceability, which means every alleged dollar must be tracked. That process may reveal something else: total revenue. How much did the Whittaker-related channels actually generate between June 2025 and arrest? Public speculation often exaggerates revenue. YouTube AdSense payouts vary based on watch time, demographics, and advertiser rates. 1 million views does not equal a fixed dollar amount. Donation surges can inflate totals temporarily, but accurate accounting requires platform data. Investigators will have it. The public does not. And that gap between speculation and data is where misinformation thrives. There is also a reputational component. The Daily Mail coverage amplified the arrest. Headlines create impression, but the criminal docket contains only structured entries. Complaint filed. Warrant issued. Bond set. Initial appearance. Those entries are sterile. They do not tell stories. They record procedure, and procedure is slow. This case will not resolve in days. Discovery exchanges may take months. Pretrial motions may challenge evidence admissibility. Defense may argue that financial disputes belong in civil court, not criminal prosecution. That distinction matters. Civil cases resolve monetary disagreements. Criminal cases punish intentional wrongdoing against the state. If prosecutors cannot establish criminal intent, charges can be dismissed. If intent is proven, sentencing follows. Meanwhile, the Whittaker family remains in an uncertain position. They have expressed belief that money was taken. They have also acknowledged not knowing exact amounts. That uncertainty will be central at trial. Jurors will ask, did the defendants knowingly exploit vulnerability? Or did they operate within a chaotic but not criminal digital arrangement? There's a difference, and that difference will determine outcome. Beyond this individual case lies a broader implication. Influencer-driven charity has largely operated without regulation. There are no standardized auditing requirements, no mandatory third-party escrow systems, no enforced transparency protocols. When content creators manage funds for vulnerable subjects, oversight is voluntary. This case may change that. If prosecutors succeed, creators may think twice before directly controlling donation flows for individuals unable to independently audit those flows. If prosecutors fail, it may highlight the difficulty of criminal enforcement in decentralized digital ecosystems. Either way, precedent forms, and precedent shapes behavior. Right now, the legal truth is narrow. One defendant charged, one ongoing prosecution, one set of allegations spanning June 2025 forward. Everything else remains unproven. The internet wants villains and heroes. The court wants evidence and elements. Those are not the same thing. Comment below with the single most important piece of evidence you think will determine the outcome of this case. Keep it specific. Keep it grounded. There is one final piece to understand about this arrest. It's not just about money. It's about access. The Whittaker family has lived for decades in isolation, socially, geographically, and structurally. That isolation created vulnerability. And vulnerability, when exposed to an online audience, becomes a form of currency. Every camera that entered their yard altered the power dynamic. Every monetized upload shifted control. Every donation link changed who held leverage. When law enforcement steps into a situation like this, they're not just evaluating bank statements. They are examining who had influence over decisions, who managed communication, and who controlled the digital gateways through which money flowed. If the state proves that one person controlled the accounts, directed the revenue, and made representations that were knowingly false, then the charges become clearer. If evidence shows shared control, informal agreements, or ambiguous expectations, the case becomes more complicated, and complexity often favors the defense. Right now, the public record confirms only this: a June 2025 starting point, an investigation opened by September, an arrest in January 2026, 11 felony counts, a $150,000 bond. That is the confirmed framework. Everything else, the total amount involved, the exact mechanics of revenue sharing, the internal conversations, will surface through court proceedings, not headlines. It is also important to separate legal responsibility from public frustration. Many people feel that the Whittakers have been used repeatedly by multiple creators over multiple years. But criminal court does not prosecute feelings. It prosecutes statutes. The defendant in custody is innocent until proven guilty. The second individual named publicly has not been charged. No court has ruled on the full scope of revenue distribution. No sentencing has occurred. What happens next will unfold slowly. Preliminary hearings, discovery, motions, possibly a plea, possibly a trial. In the meantime, the Whittaker family remains at the center of a situation they did not design, one shaped by cameras, monetization systems, and competing narratives about who helped and who harmed. This case will ultimately answer one narrow question: was there criminal exploitation? Not mismanagement, not disappointment, not broken promises, criminal exploitation. And until that question is resolved in court, the only honest position is restraint. If you followed this case closely, comment below with one word: trial or plea. Which outcome do you think is more likely and why? Thank you for watching this video. Click here to watch another video that might interest you.